Let's do it.
Right. Welcome, everybody. It's nice to see so many, well, many familiar names amongst those attending. This is intended to be an interactive session, so our role is co-moderators, and there must be 3 of us, and we have Sergey Treschev, who is a managing partner of Squire, Patton, Boggs in Moscow. We're supposed to have Katherine Simpson, who is an independent arbitrator with Simpson ADR in the US, and I'm myself as Andrey Panov. I'm counsel with the international arbitration practice of Allen and Overy in Moscow. So our role today is supposed to be leading the discussion, and your role as the active attendees is to actually share your views and experiences with respect to
That's why I can say we didn't prepare any special presentations. We just wanted to talk from in the very beginning about the important issues which are related to the topic of our panel, and then to have a conversation with all of the participants, because we have active participants, as they call it by the current organizers, who can be asking questions and speaking using Zoom, and the others using the chat. So that's why the active, so-called active participants, they're recommended to be called panelists, and the others like the audience. So, Andrey, I think the floor is yours, then I will continue.
Sure. Thank you, Sergey. And if you could keep... Okay, we have Katherine joining us. That's wonderful. I'm going to make her co-host. Hello, Katherine. You're on mute and your camera seems to be
switched off. Yeah. That's what I was afraid of.
Well, anyway, I think we just keep going and we'll wait for Katherine to join us fully.
Yes, I apologize.
Hello.
Hello,
Welcome.
It's the great computer rebellion over here.
This is one of the challenges of e-advocacy everybody is facing these days. Because
yes, it's a good thing that we planned this into the presentation, right?
Yes, and you played your role exceptionally, I must say. So really well done, and really you have solved your problems really on time, so that we could get started.
Yeah. It's like one of the e-tips. We should have get the advanced test of the system and the general rehearsal.
Yes, and then the tip is, no matter how many times you did the technical test, something might get wrong at the day of the hearing.
Yes, that's true.
So yeah. Anyway, I think we were going to talk about about e-advocacy, but e-advocacy from different perspectives. So we will have Katherine covering this issue from an arbitrator's perspective and share her recent experiences of how she acted as an arbitrator in virtual hearings, and we will be covering this from more counsel perspective, I believe, and obviously the audience will or the participants will share their experiences. And starting with probably the counsel's perspective, very briefly from my side, I think obviously there are many challenges to do this virtually, and one of the main challenges is that it is absolutely new to us. So most of us are not familiar with with any practice of pleading the cases, let alone cross-examining the witnesses online. even though some people obviously have had some experience in this regard before COVID-19. And there are many issues, starting from the technical issues which we have now experienced, and which are probably inherent to this very setting, all the way to the very unusual for our brains way of interacting, because usually the way, oh, Katherine, we can see you now. Wonderful. Hello, hello, hello. So yeah, our brains developed for millions of years reading multiple nonverbal tips, and this is one of the main features our brains have. And now all of a sudden you only have that much of a person in front of you, and you totally lack most of the nonverbal skills, most of the nonverbal messages you would be getting otherwise. So overall, I think virtual hearings are very tiring for our brains because this is such an unusual setting. Our brains have to adapt. Our brains have to try to read the faces without being able to observe the body posture, the hand movements, well, anything really, apart from the very tiny facial expressions, if the camera is okay, which is not always the case. So that was, yeah, I think that was it from the introduction perspective. And then, are there any, would any of the participants would like to share their experiences or their criticism of e-advocacy practice they were facing in their professional lives recently, or not necessarily recently?
I didn't have an experience of e-advocacy, but I had an experience of e-trial. And to me, it's significantly different. If we compare it with sports, it's like to substitute soccer with computer soccer.
With football.
Oh. That's good. You don't have this adrenaline rush. You don't have this instinct of like opposing the other party when they're present in the same room with you. And you are right, all these tips, all these signs which can be read during the hearings, they're limited because sometimes it's just the face, as in my case right now, because my room is tiny and I cannot follow recommendations of civil protocol or National Arbitration Association of the US, like putting the camera in a way that all room will be visible to avoid presence of some third parties. So yeah, it's a very interesting experience, but that's reality. And some countries are now open for traveling, but they may be closed again. And yeah, we need to change together with the times, I think.
Well, actually, and picking up on both of your points, am I actually muted?
No.
Can you hear me?
Yeah, we can hear you.
Okay, great, because I wasn't lighting up. On nonverbal, I tend to move my arms around a lot, but you can't see that I'm actually gesturing right now. If I'm going to gesture like I would be in a normal conversation, I have to do it right next to my head, which is, for a little applause, it works, but for everything else, not so much. And the nonverbal tips are indeed important. I was giving a presentation the other day, and somebody asked a very sensitive and charged question, which was, well, I'll just put it out there, but if somebody's a tribunal secretary and their boss tells them to write the entire award, wouldn't that person do it just for the money? And my answer to that question was, basically, my parents have taught me since I was very young, if all I'm after in life is money, I can always become a plumber. The plumbing industry is open. And it was a very awkward joke because I couldn't see anyone in the audience's reaction. At least right now, I could see Andrey's reaction, and it was gratifying and even retroactively so to the presentation that I just gave. So thank you very much for that little that test run. But in addition to it being, it's tiring for our brains in a way that in-person communications are not tiring, especially because we have to mimic eye contact when we're really not making eye contact. I'm giving you that impression of eye contact because I'm staring directly at a camera and wishing that I could really see your reactions to everything. But, rather than let my mind just get tired and wander off during a long hearing, I do all of these in the standing upright position. I stand because I know that even though I might be able to sit and do something for 3 to 5 hours, but thinking-wise and working through complex problems, 2 hours, 2.5 hours is a really good measure for me. And that's about all that I want to stand still in one step. So my legs are a coffee break reminder.
Katherine, may I ask you a question? Well, you are talking about like acting as a sole arbitrator, but if you are in a panel of 3 arbitrators, what will be your reaction? Because when you're sitting just at one table, side to side, and you can look at each other, and also there will be some non-verbal communication between the arbitrators, which can be also interpreted differently by the parties, experts, and witnesses. But how will you feel if you have such an experience? What was that experience when 3 arbitrators are just on the screen and you see them as all other participants in the proceedings?
Fortunately or unfortunately, I can't answer that part from experience because I've only been a sole arbitrator in a multi-party international dispute that was done completely virtually. So I only had all of the different parties. Now, what I did in that proceeding was I tried to mimic the in-person experience as much as possible by explaining to the parties really exactly where I was probably going to be looking and why and how they should not be upset or distracted by that. But going to your specific question on tribunal dynamics, in an in-person hearing, my experience has been is that arbitrators will pass short notes to one another because it's not always the case that each arbitrator has email or a messaging service open on their computer. Many are perfectly happy to put their computers right onto airplane mode and take notes fully focused on exactly what's going on. So you'll see notes going back and forth, but also within an agenda where the arbitrators will say, after 2 to maybe 3 hours, we're going to take a break. And so I suppose that's the really roundabout way of saying, well, the online setting is certainly different, but not as different, especially if the chairperson is providing a good roadmap for what is going to be happening during the proceedings. If you like, I could share my little roadmap.
Yeah.
Okay. Gladly. Well, it was a 3-party proceeding where we had the risk that one party was not going to be attending. And for me, the important thing that you get out of a hearing is the hearing transcript. The transcript is what you're going to be using to later write the award. You're not going to be, well, really, you're not going to be looking back at video and seeing, who maybe reacted in what way. So when I opened, I said, ladies and gentlemen, as you can see, I'm looking straight at the camera and I'm giving you the impression that we're making eye contact. And for many of you, this is probably a comfortable feeling, and it looks like I'm absolutely paying attention exactly to you. except that right now I'm looking directly at a camera and I can barely see your face. Actually, it would be my preference if when claimant is speaking, I was looking over at claimant. Now, when I do this, it looks like I'm dozing off and going completely off screen, but really in my office setup, I have a screen right here that is dedicated to claimant and claimant's team. And when respondent 1 is speaking, I would like to be looking at respondent 1. And of course, it just looks like I'm staring off in the opposite direction, but at least this way you can know that when I'm looking over here, I'm really looking at your team. And the same for respondent 2, which I think at the time, like I had a one monitor above the other setup for that. But I went on and said, I've also got all of your exhibits printed out, and you might see me looking at them. You're also going to see me doing a little bit of this, and that's because I like to take notes by hand, especially when I'm doing an online setup. So you don't need to be worried if you see this little pen jiggling around beneath the screen. Now, most importantly, though, this is not a contest, and this is going back to what I said about making a transcript. This isn't a contest to see who can stare most intently and most sincerely into the camera for the longest period of time. I understand that it's uncomfortable, but we're here to get the information from everybody who's going to be presenting. And I don't intend to hold anything against anybody for looking at their notes or looking at the teams that they want to be looking at while testifying. Now, I also pointed out, because I've got an interesting facial tic that isn't really coming out so much, but I'll make it show itself. I have a wild eyebrow, and it stays as I smile throughout the day or raise my eyebrows, sometimes it gets a little bit stuck in the upright position. I'm usually pretty good about angling my body so that I can look like a normal human being. But throughout cases, my eyebrow can kind of travel up my forehead, and I can look either skeptical, amused, uncomfortable, anything really, more depending on the person across from me's anxieties than what's actually going on my face that I can't feel so much, because it's just the muscle gets tired and it's a muscle cramp that I can't really feel. So I demonstrated this to them, said, don't worry about my eyebrow. If I notice it's up, I will give it a manual letdown. It might return to the position, but my eyebrow is completely not communicative. Do not take any discomfort from that. And they laughed, which was a relief. And then they also thanked me, because they said that that would have driven them up the wall if during testimony they would have seen my eyebrow travel north and then stay there. So it was a nice icebreaker, and I think it also enabled the witnesses to speak as comfortably as possible in what were really kind of uncomfortable settings. And actually, on the point of the non-participating party, we had to think about how we can make the hearing as accessible as possible, even if somebody might not be participating. In an in-person hearing, the tribunal might leave the hearing room completely open. Everybody get out their favorite book and just start reading on the hopes that the non-participating party would arrive. Well, in an online hearing, we decided that that meant that we would leave the hearing open and the camera going for the 2 hours that the other party would have had to present their case. We left it completely open, emailing that party throughout to remind them and let them know how they could participate if that was their wish. But I think that by leaving the hearing open and providing all of these opportunities, I was able to protect the final award from any sort of disagreement, let's say.
But talking about those who do not participate, if the party disagrees with the virtual hearing, and for example, the hearings were ongoing before the pandemic, and then the pandemic times started, and the arbitrator proposed the parties to follow the virtual way, e-arbitration. I know that National Academy of Arbitrators issued a guidance where they say that the arbitrator in such a situation, when it's pandemics and it's an emergency, may issue an award even contrary to the opposition of one of the parties to participate in virtual hearings, and even if they are not present. But in my point of view, it may be later on contested because they may say that, well, it violates our rights and violates the New York Convention. What's your point of view?
I think in large part it does depend on the arbitration rules and what kind of consent is really required. Is an exuberant, yes, I consent to a virtual hearing required for a virtual hearing, or is a lack of objection required that would enable the tribunal to then issue the procedural order to have a virtual hearing? In the situation that I'm discussing, the party actually did not participate throughout, one of the three parties, which in a pandemic makes it especially difficult because, of course, people can have a variety of perfectly unrelated to the arbitration reasons for not participating. And in our case management meetings and all of our attempts to engage the non-participating party, we did so with, in the background, this idea that this party might be ill or have a family member or a firm member who is physically unable to do this right now, and that this is a time that requires that kind of flexibility, understanding, and especially non-punitiveness. In an in-person, non-pandemic situation, of course, rules allow arbitrators to draw different presumptions, but for my hearing, we expressly decided not to do that.
Thank you.
I think we should try to hear from other participants as well.
I do not object.
Right. Is there any consent from the audience? Any comments in the audience? And I think we will now have to figure out how to, I think that the way to deal with this would be for the members of the audience to raise their hands if they want to share some of their experiences, and then we will see how we deal with that. Anybody? Before I started calling names? Right. So I think the first one was Alexander Panov, sorry. Let me see if it works. Oh, yes. Hello, Alexander. Can you, yeah.
Hello, Andrey. Hello. Yes, I was very taken in by your observations concerning the presentation of somebody who is giving evidence virtually, and I immediately recalled an experience I had, which was in the pre-pandemic days when we had a hearing in London, and I had to cross-examine two witnesses who were in Moscow. Now, one of them was a very seasoned attorney who throughout the cross-examination kept a complete poker face. So I don't think there was any difference between him giving live evidence in front of the panel with all being in the same room and him being on the video.
Could it have been a picture of him in front of the camera?
There was. He was, no, I see what you say. No, it wasn't a static image. No, he was moving his lips and he was moving his head slightly, but otherwise there was nothing in his demeanor that would, betray his emotional state. The other witness was a young girl, and she was a lay witness, and she was with a new baby. And that is why she had to give her evidence lying on the floor and whispering. which created a bit of a sinister impression at times when she was confiding in the arbitrators or giving her responses in a subdued and hushed tones, but the circumstances were of course made clear to the tribunal, and so her evidence wasn't affected by that. As you were speaking, I thought whether you can foresee a development in the directions that are these days routinely given, say, in the course of disclosure, where electronic disclosure is regulated to an extent by providing the format in which documents must be given, by requiring them to be given in either a native format or some presentational format. What I'm thinking about is that if the virtual hearings of this sort were to become the rule, might we expect a bit more flesh on the bones of procedural directions? You could, for example, provide that there should be a certain angle to the camera, or that the witness should be seen at least from the waist up. That, of course, will give people opportunity to still give evidence as we hear it happens without wearing the pants, just from the waist upwards.
Confession time.
What I'm saying is, if we are having more and more of that, and we want to mitigate the deficiencies and shortfalls of the electronic format, then maybe this can be addressed by some sort of technical directions and some sort of technical format that can become perhaps even standard as time goes on.
Well, personally, I think that it is wonderful that the tribunal was so flexible as to allow the witnesses to testify and answer questions in the positions where they felt most comfortable. Because if the contest is to see who, while performing extreme yoga, can endure a cross-examination by 3 people in front of another audience of 3, then that certainly privileges a certain kind of demeanor. I mean, many witnesses are trained to look like they're making eye contact, but not actually to do so. You pretend like you're looking at the back of somebody's skull bone. It makes it look like you're making eye contact, but really you don't have to react to any of their facial expressions if you don't want to. For my hearing, we talked about what was expected as far as what people should wear, and we arrived at business, but only above the waist, and that this would not be controlled or scored by the arbitrator. And I was grateful for that agreement by the parties. Now, as far as the different document format goes, of course, this is going to give a whole new role to the tribunal USBs, the party USBs that they send around, but also potentially virtual hearing bundles where you can have your entire case bundle in a linked set of PDFs that is very actually easy to use. There are several companies in London providing these services now. One started by a colleague, Hamid Beg, at 33 Bedford Row. So just to put that plug out there, since we're all here together. But as far as actually dictating how parties should testify, we know that they're supposed to testify without reading a text from somebody else or having somebody else prepare their answers. But, if somebody's lying on the floor versus standing up, at the end of the day, it all just produces a transcript, and it's the transcript that is going to be used to make the award, not the picture of somebody sitting up or lying down.
Well, what about credibility, though? Certainly in the court setting, and for example, in the English jurisprudence, a trial judge has a function of assessing the demeanor of the witness, and it is accepted that the demeanor may have an influence on the judge's assessment of credibility.
Yes. Well, And
The transcript will never give you that opportunity, as the appellate courts always say whenever they're looking at transcripts. They say, we can read the words, but the judge had an advantage over us in assessing the demeanor of the actual witness, and that is why we will be slow to interfere with that assessment.
Yeah. And sometimes I do question the ability of judges to accurately evaluate somebody's demeanor as far as whether truth telling is going on. Of course, American and English attorneys are trained in cross-examination, which, you know, maybe somebody has a facial tic that lets you know when they're lying, but really it's the inconsistent information that might come out of a cross-examination, or the repeated information in exactly the same words as have been presented before, that might have a real impact on credibility. Most arbitrators have not been trained in cross-examination and do not hold degrees in psychology or psychiatry. And I do question many arbitrators. I do wonder about many who think that as an arbitrator they can divine whether someone is really telling the truth based on how much they sweat while being interrogated by a room full of strangers.
But Alexander, Katherine, Andrey, do you think that maybe the credibility may be increased by using like the assistance of so-called national centers, or like arbitration centers, or national hubs as they call it in some other jurisdictions, where some neutral observers will follow the, they will be listed in the list of presence, but they will be like guardians, like controlling that and monitoring the situation, avoiding all kind of a risk of some kind of interference on the witness statements. Maybe, yeah.
I'm skeptical.
On the oral statements, maybe somebody could help to ensure that somebody is not reading from, now I even forget the word, reading from prepared text that's being projected onto a wall. But we're also in a pandemic, and the fact that those facilities might not be open or available should not prevent parties from being able to present their case. I mean, after all, with an actual witness statement, you don't know until it's been questioned and also compared to the other witness statements as well.
And really, it's not a university examination where you have to have a right or wrong answer to a question. It's really about whether the arbitrators believe in your version of events. And honestly, I'm very skeptical about somebody standing behind the screen and whispering to the witness the answer, and the witness not appearing distracted in any way, being on camera, because most of the lay people inevitably would get distracted, and then they will mix things up, and it will actually turn much worse than expected. So I don't think this is the real risk or a real problem we need to deal with. Mm-hmm. And I mean, I agree, before the pandemic, there were ways of dealing with this, and the opposing party could have sent somebody to sit there with the witness to ensure that there is no interference, but it's not that helpful during the pandemic. I think there was another hand raised by Rupert de Cruz, but then he left. Right. Any other comments or observations from the audience? Really? And this is you. Well, come on, guys. You signed up for an interactive session. Be interactive.
I remember that Katherine, during our preparatory call, said that there was some kind of a complication with the witness oath, and that's maybe a problem in different jurisdictions. Yes. And how did you solve it? Because it may be interesting for the audience, and maybe them.
Well, in that, fortunately, They agreed that the witnesses did not need to testify under oath, and that my oath as arbitrator, which was also prepared, sworn under the laws of another state in the United States, would suffice. And so fortunately, we didn't really have to go head-to-head on that. I understand that there are rules in some parts of the United States now that allow arbitrators to issue oaths online, depending on their licensure as an attorney. But, you know, my prior experience in international cases was that oaths were never actually issued. People would be asked to promise that what they were saying was true and accurate, or to the best of their abilities, or reflected their sincere belief. A promise, a bit of hair splitting, a promise being slightly different from an oath. Perhaps the difference being criminal or financial consequences for telling a lie. But they really, in my mind, it didn't have much of an impact on whether the person was going to be telling the truth anyway.
Mm-hmm.
So we didn't have to solve that problem, fortunately.
Katherine, as an arbitrator, can I ask you a question? What would be your top tips for attorneys appearing in front of you virtually? So what should they do differently to sound convincing and to do it properly in a virtual setting?
Well, first, they can speak exactly as you are right now, with that cadence just perfectly.
With the same accent?
With the same accent, really. As an American, I can confirm that Americans prefer people with accents when talking about anything. So yeah, there's a little background tip on America.
I didn't know that. Thank you.
Oh, we'll talk. It's fun. Americans and accents is a wonderful topic for probably a later presentation. But they can do exactly what they do in in-person hearings. Speak and present their case as they believe it is most accurate and effective to present it. There's no magic potion to this. Although one thing was, and I explained this to the parties, was that if I would need them to stop speaking, or if I had a question, I would make that abundantly clear on my own, and there was no need for them to stop speaking and say, excuse me, I see that you looked over there and looked over here, did you have a question? Because that can really take up a lot of time. So I asked, don't worry about a thing. I will ask as soon as I have a question.
But talking about like in-person arbitrations, I think one thing will be missing in the online arbitrations, because I had two cases where the other party brought with them like copies of or models of installations, and it was like visible, and they could show to the arbitrators that this is acting like that, and if you turn off this device, it will be moving in a way that cannot be like it couldn't act like for example, the claimant says, and it will be quite complicated, I think, to do even using the camera during the online arbitration.
Actually, that sounds like a lot of fun. You would be surprised at the number of things I have had delivered to my house ever since March 13th, the last normal day of the year in the United States, a Friday. I've received so many packages, and packages full of things that I've had to put together myself or have been put together for me, as well as arbitration things. I think if the parties were up to it, if they were to mail their models to me, I could have them ready to go during a hearing so that they could say, okay, Madam Arbitrator, if you if you lift this like so, and you can see how this moves like so, wouldn't that be wonderful? Because then I would still get the ability to lift it and touch it and say, oh yeah, this is a really interactive expert presentation here. That would be great.
I agree. Oh yeah, that's fine. And well, of course, there are witnesses and experts and even representatives of the parties who are not, for example, English speakers, and the interpretation is needed. And so, what do you think? Will it influence the quality of the interpretation? Like the interpreters will be subsequent or simultaneous? How the online can influence this aspect of the arbitration?
You know, I would imagine that they would be simultaneous translation, just like in an in-person hearing. And actually, all this week, I've been at UNCITRAL as a delegate from Arbitral Women. And the simultaneous simultaneous interpretation there has been brilliant. Though, I mean, of course, they have full-time staff who are trained in simultaneous interpretation, but doing completely online UNCITRAL meetings for a week is also new for them, and they've been able to adapt quite well. Mm-hmm. So, I imagine that the companies providing these services would be eager to show their abilities. But I mean, and like you, I also speak foreign languages, and I don't have a problem with people speaking foreign languages and checking words and restating things. I understand that that's part of the territory.
Of course. Mm-hmm.
I guess for counsel, it takes more time to prepare for virtual hearings, particularly in the setting we have now, where everybody is separated from his or her legal teams. So everybody is by themselves. Do you think it takes more time to prepare for an arbitrator in a virtual hearing as well? Assuming you have all your screens already set up from the previous hearings, do you find it any different from an arbitrator's perspective?
Well, I mean, I don't have to take a 10-hour flight there or back or find a hotel. So there are certainly immediately visible time savings that I can see. And come to think of it, I think that it could take less time. I'm struggling to imagine for myself why the preparation would take more time, because the preparation is actually very easy to set up, just like we've all set ourselves up on these computers. We've got the technology, even if the chairperson's going to be late. Rule to live by: the chairperson is never late. Chairperson always starts on time. But yeah, I don't see how it would produce, the actual hearing itself would produce an additional burden on the arbitrators. Where the pandemic is producing issues is with the floods of motions to, in anticipation, to postpone or add additional procedures that relate entirely to the pandemic. These are new, sudden motions that have been flooded into every arbitrator's inbox, seeking to, move hearings, stay hearings. Perhaps some parties are even agreeing to agree on certain issues, which is a good thing. But
confidentiality, maybe a lot of statements and recommendations just increase confidentiality and liability for breach of confidentiality, like for making unauthorized recording of the arbitration hearings. How can you deal with this? Because it's not so easy to control.
I agree. I agree. It's not easy to control. And for my hearing, I used the American Arbitration Association's hearing facilities. Their staff did all of the technology, putting people into waiting rooms and doing their best on their side to block recording. But yes, there's literally nothing that can be done to prevent somebody from sticking a camera in a corner, focusing it on the computer, and putting it somewhere. But that is also a risk in an in-person arbitration as well. I've been tribunal secretary in several cases where I have personally caught people making unauthorized recordings of hearings, and it happens, and when it happens, it's addressed. So I don't think that it is maybe easier or more difficult because we're all now online. That being said, online has its own risks, and I take a little bit of guidance from the fact that many medical schools and doctors' offices are now conducting highly confidential and privileged patient meetings with nudity via Zoom. And though we haven't seen a flood of those videos come out yet, so I hope that that the same will be true for arbitration.
That's fine. We have 2 minutes left, I think.
I've been talking my mouth off.
Well, thank you very much. You were the most active participant. Now, people in the interactive session at the coffee house debate, come on, last chance to raise your hand and share your views and experiences about e-advocacy you had over the past 6 months or so.
And to show you a cup of coffee to us.
Cheers to that.
Cheers. Oh, yeah.
This is obviously a glass of vodka.
Yes.
Oh, yeah. So then I think.
Well, I mean, Sergey, you are preparing, I understand, for several virtual hearings coming up.
Yeah.
If you could, what would be your one wish for them?
Well, my wish, as we talked before you joined us, we talked with Andrey, and my wish that all technical devices working properly and all communication would be perfect. That's my best. Andrey disappeared,
That was an ironic moment to disappear.
I know. No, that's the story we were talking about. Yeah, and the most important person, the host of the panel, just disappeared.
But then Zoom itself basically brought me back. So the technology works. It just my internet connection probably was affected by my glass of vodka.
Okay.
Right. I think unless we have, obviously this is the topic we could be discussing for ages, and I would love to discuss it with you for ages, but there is a next entertainment coming up in 15 minutes, which is the live hearing. So I think we should now.
And we will check what will they use from our comments.
Yes, and we will check to what extent they were diligent enough to listen to our tips on e-advocacy, to the extent we had any. Well, thank you very much. It was my absolute pleasure to be co-hosting this with you, with two of you, and thank you for the audience for at least listening, and Alexander for taking lead in participating actively and sharing his views and experiences with us.
Thank you.
Have a great day, and hopefully see you around at some point in person.
Yeah.
Looking forward to that day.
Next year.
Yeah, well, hopefully before that. Bye.
Bye.
Bye-bye.